Are you arrested? So,
Arrested, and just so the record's clear, 1 and 2 we agree are admitted.
Received.
Thank you.
Mr. Singer.
Thank you. Good afternoon, Dr. Black. I wanted to ask you a couple questions regarding your curriculum vitae. Do you have that in front of you?
I do.
That is Exhibit 2. And on page 4 of your curriculum vitae, at the top of the page, there is a heading Expert Witness. Do you see that?
I do.
And you wrote there, and I just want to make sure I'm quoting this correctly, you said, qualified as an expert witness in state and federal courts related to police use of force, decision-making, officer-involved shootings, police tactics, police training, incident command, and police/jail operations. Did I read that correctly?
You did.
Is it fair to say then that the times that you have been qualified as an expert witness relate to police use of force as opposed to civilian use of force?
I'd say the majority would be related to police use of force. That's correct.
In your CV, you have a section where you list the cases that you have been involved in as an expert witness or a consultant. Those begin on page 24 of your CV. There are 57 cases that you list running from there until page 32. Is that correct?
That's correct.
Is it correct to say that in every single one of those cases, one of the parties is a law enforcement agency?
No, I don't think that's correct. At least on some of the advisement. I've advised on civilian self-defense before. I'd have to take a look at which one and when I'm. So the short answer to your question, sir, is no. I'd have to go through them, but I have advised on self-defense cases before.
All right. Well, let's go through them quickly here. Number 1 is a case involving a defendant, Washington County, Oregon. Correct?
Yes.
That's your home county where you worked as a sheriff's officer for many years?
That's also correct. It's not my home county now. It's a home county where I used to work.
And that's a case involving a law enforcement agency since the county is a defendant, correct?
Yes, absolutely correct.
Number 2, similarly, Clackamas County, Oregon, same situation, correct?
Same situation, meaning that a law enforcement agency was involved?
Yes.
Yes. Mm-hmm.
Number 3, a police shooting in the Northern Territory, correct?
Correct.
Number 4, Chicago Police Department shooting, correct?
Also correct.
Number 5, another Chicago Police Department shooting, correct?
Correct.
Number 6, a case involving Jackson County, Oregon, a law enforcement agency there, correct?
Correct.
Number 7, a case involving Seattle law enforcement agency, correct?
Correct.
Number 8, a case involving San Jose law enforcement agency, correct?
Correct.
Number 9, a City of Aberdeen, Washington law enforcement agency, correct?
Correct.
Number 10, a St. Helens, is that St. Helens, Oregon?
That is correct.
Law enforcement agency there, correct?
Yes.
Number 11, a Washington County, again, Oregon law enforcement agency, correct?
Correct.
Number 12, King County, which is Seattle, Washington, law enforcement agency, correct?
Yes, sir, it's correct. And
Number 13.
Go ahead, sir.
Number 13, Yamhill, Yamhill County. I don't know where that's at. Maybe you do. Well, I'm sure you do. But anyway, that's involving another law enforcement agency, correct?
Yes, correct.
Number 14, Springfield. I'm not sure which Springfield that's at, but that involves a law enforcement agency also, correct?
Correct.
Number 15, Portland State University. Is that involving a law enforcement agency?
It's a type of agency. It'd be campus security.
Number 16, another Washington County case, law enforcement agency, correct?
Correct.
Number 17, Eagle Point Police Department, another law enforcement agency, correct?
Correct.
Number 18, Yakima County, another law enforcement agency, correct?
Correct. And sir,
Number 19, go ahead, I'm sorry.
No, and again, if you'd like to read through each of these ones, but as a courtesy to the court, I think maybe there's a misunderstanding in the statement. What I said is I have advised in self-defense issues. Not all of that. If you notice when I testified in this morning's thing, I said 60 instead of 57. I routinely get calls. I issue things in self-defense. If you're asking if I've testified in a self-defense case, that would be different than advising. But if you'd like to go through the remainder of this, we can.
Is it fair to say, though, Dr. Black, that the 57 that you've listed in your CV all involve law enforcement agencies?
I think that's fair to say.
Okay, thank you.
Your Honor, I think that statement is, I understand it's cross-examination, but sometimes he's a plaintiff representing the plaintiff who was possibly shot. And was there a law enforcement agency? It's a misleading question.
Well, then the witness is an expert witness, so I think he can handle it. If he doesn't, you can cover it on redirect.
Sounds good.
Dr. Black, you also have a long list of trainings and instructions that you've done, and I have looked through this list. Can you help me focus on the ones in which you have trained on civilian use of force as opposed to law enforcement?
Well, what do you mean by civilian use of force? Just anybody that doesn't have powers of arrest?
Let's go with that definition, sure.
Okay. So, and would that include, we'll call it military militia or self-defense forces from a military perspective?
I would lump them in with law enforcement, not civilian.
Even if they were not military forces per se, but civilian, we'll call them augmentees.
Why don't you point me to the ones that you're referring to on that particular point?
Well, I can't. I'm trying to answer the question the best I can. I routinely trained those type of personnel, and I didn't list every mission I've been on in 30 years of the military. Again, I'm just making sure that we have clarity of the question. So I'll start with the first one. What page are you starting on when you say I'm looking at your training?
Well, I'm focusing on pages 33 to 38, which I'm under. Let me just make sure I understand those pages. They are headed up with a heading that says courses, parentheses, instructed, designed, and authored, close parentheses. Am I correct in understanding that those pages contain the programs or seminars that you have either presented at or been the primary organizer of?
Well, I would say they highlight the ones that are, the short answer is yes, I've done those, but it's not a exclusive list, much as the same way my advisement on the cases or the first paragraph that you read referenced the listing of expert witness doesn't say that that's the only thing I've testified for. So I'd say it's a good list for highlighting.
So let me just, I focused on pages 33 to 38, and we'll get back to those in a second. Okay. But Dr. Black, maybe you can help me understand your CV and the way it's organized. I just want to make sure I'm up to speed on everything. Is there anywhere else in your CV where it would list potential trainings that you've done on civilian use of force other than pages 33 to 38?
No, not as a list. There's reference, like I said, and I've already answered, is that I would routinely do this as some of the things for my military mission, but I didn't list everything on that, nor would I only do that. As for formal listings, I say 33 is a good page to start.
All right. Now, can you help me in those pages 33 to 38? Can you identify any of the trainings or seminars that you've done with regard to civilian use of force?
Yeah, sure. Well, now again, civilian use of force, meaning, well, okay, we'll just go for it. And then if I need clarification, I'm sure you'll ask. In The 2019 course, supervisor and that type of stuff, I'm looking on page 33. 2019 instruction for Deschutes County Sheriff's Office. There were civilians in the class, and part of the subject material covered would have been self-defense issues and the right of civilians to use force within certain things, so that police understand that as well as anybody else in the class did. Moving on down the list, Metro Academy is primarily police, staying on the same page. The Survival Skill Council chair and lead, we routinely taught civilians who oversaw within the committee the parameters of use of force to include civilian use of force parameters, in addition to police, peace officers, corrections officers, and any differentiation between that. That would take you from 2017 through 2015 with the same type of training. Moving to the next page. And again, these are, if you notice, from 2010 to 2013, or my listing there is 2006 to 2013. It's a highlight of what was taught. It is not every single class that was taught. Use of Force Review Committee, mentorship, lead instructors. We taught in the Civilian Police Academy on there, which I'm referred to as the Citizens Academy. So we not only taught citizens, taught reservists, but also taught the differentiation between self-defense, peace officer use of force, and the differentiation within the statutes and the understanding of self-defense regardless. Adult learning theory, and I'll just stop there since the next one is 2004.
All right, was that the end of the list?
No, I mean, I can keep going back, but that's 15 years in the past, unless you want me to go all the way back to 30 years.
Well, your list on page 38 begins, it looks like, in the year 1998. Is that correct?
That's correct.
Okay. So let's go back all the way to that. You had left off in, I guess, 2006. Let's keep going, and I want to make sure I'm not missing anything in those earlier years.
Yeah, no worries. Not listed. I'm on page 34 now. The note there for deployed for the military, that would probably be the time frame I would have done some security training for both civilians and police agencies, upcoming police agencies. I want to say more likely than not, it probably was for Bosnia. I think that's right. I'm on to the next page now. Washington County annual patrol training, use of force updates would have included the Reserve Academy, Civilian Academy, which is listed there, which is instruction to citizens and civilians to include all aspects of whether it is a civilian use of force in defense of property, use of force in defense of person, all the other different issues. 2002, same cross training occurring there. Reserve Academy, Civilian Academies, instructors of instructors type academies.
Dr. Black, could you, for the court reporter's benefit, could you slow down a little bit, please?
Absolutely. My apologies.
Thank you.
2001, again, deployments. Depending on where I was at, there would be some training overseas. Same type of training, Reserve Academy, Civilian Academies, regular academies, the differentiation between self-defense, the concepts, use of force in defense of yourself, defense of property, defense of person, defense of another. And then there was, and I don't see it listed here, but I did, I was the primary representative to the Washington County Human Rights Council, and I did, as part of my instruction there, help them understand use of force at a, they oversaw basically, they were a diversity inclusion effort, still are today, and understanding how from different countries, how the perception of force at a civilian level is done. And that would bring us back to your point of 1998.
Okay, thank you very much. You have a doctorate from Capella University in Minnesota, is that correct?
Yes, sir.
And that was from the School of Business and Management, is that right?
Actually, yeah, I'm not sure of the exact title, but the School of Business was the common reference.
What was your focus of your dissertation?
Intelligence, but formally, how people take visual information, in this case, visualizations, but visual information, with the moderator or mediator being critical thinking, and apply it forward into a decision process.
Is your dissertation published?
Yes, sir.
Is that something that is accessible on the internet?
Absolutely is.
Have you ever testified in a court in the state of Wisconsin?
Not that, no, sir.
Have you ever consulted on any case in the state of Wisconsin?
Not that I can recall.
I want to turn to your report, which summarizes your opinion in this case. I believe that is Exhibit 1.
Correct.
Do you have that in front of you, Dr. Black?
I do, sir.
The first page of that report is entitled Expert Witness Preliminary Report, dated July 31st, 2021. Is that correct?
Yes, sir.
Is this the only report that you have generated in this case?
Yes, sir.
It indicates that it is a preliminary report. Why does it say that?
When I got it, it was, let me rephrase that. When I was receiving the evidence, due to the time compression of getting the report in, I knew that maybe some evidence may be arriving later, so to speak. And so knowing that, I basically made this as a preliminary report, thinking that there may be additional, anything from deposition interviews, things that could give me a little bit more insight into the perception of the individuals involved as compared to just the level of video.
Since you prepared this report, have you received any additional evidence?
I would have to take a look within my files. The short answer is I don't know. I've received files. I'd have to examine them to see the dates, timestamps on them if they came in after July 31st.
Do you know whether or not you have actually reviewed any of that information?
If I received it, I would have reviewed it. I would have added it to the input ACE file or something else. Again, I'd have to go look at the timestamps.
Are you able to tell us today whether or not any of that new information that came in since the date of your report has changed your opinions in this case in any way?
No, I can accurately say any evidence that I've reviewed up to this point that's been given to me, the preliminary report that I've given, I see no reason to alter its conclusion. That I may change a couple words to make the arguments a little bit more easy to read, but the main content of it, I haven't changed that.
One of the things that you talk about in your report is the time span of these various shootings, and you testified earlier the methods that you use to measure the gap between the shots that were fired by Mr. Rittenhouse. Is that correct?
Yes, I testified to that earlier.
Why is that important to your opinion?
It helps me, it gives context. It's a baseline. If I can understand the objective baseline, it helps me understand the other things and their reasonableness. If I know that the shots were a quarter of a second apart, but someone, when they're speaking to it, says it felt like it took a lifetime, or felt like it was really long, or felt like it was seconds, I begin to get insight into what may be going on in that person's decision making as compared to the objective timeline, which is borne out by the objective evidence.
In this particular case, do you have any information about how Mr. Rittenhouse perceived that time?
I do not.
So other than what you've just described, is there any other reason why the time span of the shots is important to your opinion?
Well, the other thing it speaks, well, there's a myriad of reasons, but it's a baseline of investigation is to get the objective frame. Time, if we can determine it, is an objective frame. From that, I can take a look at many other things. Could a person have performed differently in the time that was actually present in the situation, regardless of what they felt, what they believed, or anything else? Can a person run X amount of feet within a certain time? Can a person do these things? The relationship of that is time-based. And so as a matter of just what I call sound practice, I try to get the timings done fairly early in the investigation as a way of giving myself an objective frame.
So hypothetically, Dr. Black, if the gap between shots here was a longer period of time than what you measured, would that impact your opinion in any way?
It could, depending on the significance and what the word longer means. I mean, if it was half a second, a second, a second and a half, just doubling up things for easy, then the idea that there could have been time, there might have been time for what we would call more deliberate decision making, or the person perceived, or had the ability to perceive such a thing, those can enter into some of the analysis. Whereas when things are tightly compressed, we'll call it deliberate decision making, is not usually the first type of decision making technique that one would go to, whether it's at a conscious or below the level of awareness level.
So in other words, Dr. Black, the short time frame between shots here gives you some insight into how much deliberation the defendant was utilizing when he was making those shots.
It might. It could also, and I'll use the same example as two different ways. So using roughly a quarter of a second, and in Mr. Rittenhouse's case, in event one, there's approximately a quarter second between shots. That is indicative of a person that it could be. I'm not saying it is, but it could be indicative of a person that has made a decision to shoot and continues to shoot until the decision to not shoot. So the first decision was potentially deliberative or potentially being pushed back and overwhelmed. But the quickness of the things in between is a person pulling the trigger during those time frames without necessarily deliberative type of decision making occurring between each. Some might be able to, some might not, but it would lean me more towards that person is at a high state of arousal, whatever that may be, fear, anger, whatever. It really doesn't there, but a high state of arousal. And what they're doing is they're pulling the trigger as quickly as they can because of whatever they are perceiving.
So let's talk about that first encounter with Mr. Rosenbaum. Counsel had asked you a question about prior threats to kill Mr. Rittenhouse that had been made by Mr. Rosenbaum. Are you aware of that?
I'm not aware of the exact framing of it, but I'm aware of the context of that evening and that being part of the context. But I'd have to look through my notes to find the exact, if you're asking for the exact verbiage that constituted a threat.
No, I'm just saying, is your opinion taking into account their prior contacts that evening?
Oh, yeah.
Between
the
Mr.
prior
Rittenhouse
context and the
Rosenbaum.
pursuit and everything else. Yes, it is.
I'm not just talking about the pursuit at the gas station at 63rd and Sheridan, the car source location 3. I'm talking about earlier in the evening at a different location. Does your opinion take that into account?
It does.
What effect, if any, does that have on your opinion?
Well, the short answer is it doesn't have a lot. I'm aware of it, and I keep that in the back of my mind as awareness, but I don't have Kyle Rittenhouse's statement or anything indicating the impact of that earlier encounter. So I'm aware of it, as I would be of any other piece of evidence. I'm not going to say that it causes a decision to occur one way or the other. I would argue I don't have the right to do such.
What is your understanding of what those prior interactions were between Mr. Rittenhouse and Mr. Rosenbaum?
Again, I can't. I can tell you when I look at them what I perceive as an individual. I can make a hazard or guess of reasonable certainty at what other people might perceive from the same type of interaction. And I think you actually already called it the concept of threat. As for what Kyle Rittenhouse was thinking, I'd have no insight to that.
Dr. Black, my question to you, and I'll restate it, was what is your understanding of the prior interactions between Mr. Rittenhouse and Mr. Rosenbach? Can you answer that question?
Yeah, my understanding of it, the way I viewed it, is they were at odds with each other, obviously. And if you were looking at it, the idea of the interaction, some might look at it and call it threatening. Other people might look at it and call it a strong level of disagreement. It could be viewed multiple ways. It is not one that would normally occur in what we would call either peaceful or friends.
And again, Dr. Black, what is your understanding? How would you characterize that prior interaction? I'm not sure what some people would say. I want to know what you would say.
I would characterize it basically potential aggressive stance is the terminology I would use at it.
By Mr. Rosenbaum towards Mr. Rittenhouse?
Yes.
And again, we're talking about earlier in the evening, not at the car source location, car source 3 at 63rd and Sheridan. We're talking about earlier in the evening at a different location.
Right.
Are we understanding one another?
Well, I hope so. I mean.
Okay. I just want to make sure. Okay. So you have considered that, and I forget the words you just used, a potential aggressive stance
behavior,
or something
stance,
like that?
Body language, whatever you want to call it.
By Mr. Rosenbaum towards Mr. Rittenhouse, you have considered that when forming your opinion in the case. Is that fair to say?
I was aware of it while forming my opinion, yes.
Now, at the time that Mr. Rittenhouse shot and killed Joseph Rosenbaum, do you have an opinion as to whether or not the defendant, Mr. Rittenhouse, knew that Joseph Rosenbaum was unarmed?
I don't.
You've watched the video, correct?
Oh, absolutely. I've dissected it.
And you would agree with me that it is a fact that Joseph Rosenbaum was actually unarmed at all times during his interactions with Mr. Rittenhouse, correct?
The investigations show that. Yes, I would agree with that.
Hold on one second.
Any evidence that I've been given shows that.
Hold on, doctor, stop.
I don't believe the question is specific as to time. If he's talking about in the parking lot at car source 3, that's one thing. If we're talking about earlier in the evening when he's going around with things in his hands, that's something else. So I don't think the question is correct as to time. It's vague.
Could Madam Court Reporter read back the question, please, Your Honor? Your Honor, the question contains a time parameter.
Well, it does.
That's the objection. The question is subsumes that.
Well, then it's an incorrect question because it doesn't. He wasn't unarmed at all times.
I don't know what the facts are.
Okay.
The witness can answer if he feels that the question is misleading or is based upon unsound analysis. So go ahead, doctor. Are you?
Yeah, I'm still here, and I apologize, Your Honor.
Wait, stop. I'm going to stop again.
I'll make sure I talk into the microphone more. I thought my voice was one of those ones that people could hear.
I can still remember your voice from... remember when that fellow...
Yes,
you know what I'm talking about.
Belgramarius.
Is that what his name was?
Yes.
Yeah. That was quite a trial. Mr. Richards was spit upon by defendant, and then he spit on the jury, too. Oh. But anyway.
Richards or the defendant spit on the jury?
Anyway.
That one.
You know what to expect.
Anyway, let's get back. Why don't we start with a fresh question, and let's take it from there.
Dr. Black, let me take another stab at this. Would you agree with me that Joseph Rosenbaum was unarmed on the evening of August 25th, 2020?
Again, given the conversation, I want to just put some caveats on it. And the video that I saw in the moments, what you called the events preceding when they had the conversation and the engagement, and the video that I saw that I'll refer to as I think you're calling it Service 3 or something similar to that, Gas Station 3, other than the bag being thrown, which could be perceived as some sort of irritant or chemical or that type of stuff, other than his physical ability to inflict harm through fists, feet, or bodily weapons, he was not, that I saw, armed with anything else that would be considered a weapon, knife, or otherwise. It does not mean he did have them or didn't. I did not see them within the evidence that I've received.
So therefore, your opinion with regard to the killing of Joseph Rosenbaum is that Kyle Rittenhouse was justified to protect himself by use of deadly force to prevent Joseph Rosenbaum from taking his gun and killing him with it. Does that accurately summarize your opinion with regard to the shooting of Joseph Rosenbaum?
No, it does not.
Can you explain to us why you believe that Mr. Rittenhouse was justified in using deadly force to kill Joseph Rosenbaum?
Again, look, the short answer is yes. The totality of the things combined, not the singular event. We have a person that was a continuous event. I'm going to call the term a continuous event from the moment of the pursuit within the parking lot depicted in the video. This person, Mr. Rosenbaum, threw something, continued to move forward, and continued to close the gap. This is representative of aggressive type behaviors within the context of anything from fires, looting, darkness, whatever else is going on. He's also willing to do this against a person that has already displayed and has on display a lethal firearm. In other words, he's willing to engage, right, wrong, or indifferent, with physical force against something that could potentially kill him. This speaks to potential intentionality, or whatever we want to call it. As I close the distance, being Mr. Rosenbaum, there is a moment in time depicted within the video where several things seemingly happen, indicated by the movement of Mr. Rosenbaum's body, the back of his body. As they close the distance, his hands are coming out. He is reaching in the direction of and appears to have made contact or be within just the moments of making contact, again, reaching for the weapon in a narrowed space, in a area that's there against Mr. Rittenhouse, engaging with him. Could it be just a physical altercation? It's possible. Could it be just he was going to try to take the weapon away and render it safe and then stop this from happening? Also possible. My analysis is it reasonable to perceive, would it be reasonable for a person to perceive that as this other person is potentially taking away the firearm, that as they do that, I will not have that mean to protect myself, and they will potentially use that against me. In all of those factors combined, I argue that it would be reasonable to use lethal force to defend against such a threat and a perception.
So I want to narrow in on that, Dr. Black. The risk of great bodily harm or death to Kyle Rittenhouse from Joseph Rosenbaum specifically was that Joseph Rosenbaum would use Mr. Rittenhouse's gun against him. Is that correct?
That's part of it. He could easily have engaged in a physical altercation alongside of that.
Can you explain to us how Joseph Rosenbaum could have caused let me rephrase that. You're familiar with the jury instruction in the state of Wisconsin with regard to self-defense and the use of deadly force, correct?
I am. I've read it.
And that talks about defending against a substantial risk of death or great bodily harm to Mr. Rittenhouse, correct?
In the concept that he reasonably believes that it would be necessary to terminate such, yes.
So let's talk about what was the substantial risk of death or great bodily harm to Mr. Rittenhouse that was posed by Joseph Rosenbaum, okay?
Okay.
I asked you if it was simply Mr. Rittenhouse's gun, and you said no, it was more than that. So what other things was Joseph Rosenbaum doing to Mr. Rittenhouse that posed a substantial risk of death or great bodily harm to Mr. Rittenhouse?
Right, and Counselor, I can appreciate the question, and I'm not trying to walk around it. You're absolutely correct. The crux of this, I would argue, or the primary weighting factor, is the fact that a firearm was involved. My argument is it is not as simple as that, and it's not taken out of context. If you were to ask me, and I was having a firearm slung across my body, and you were a friend of mine or anything else, can I see the gun? And I hand it over to you so that you can examine it. The distances are the same. The gun is the same, but the context is not. The intent, the willingness to do harm, and these type of things. In this case, I don't disagree. The gun is what raises it, in my argument, that a reasonable response, not the reasonable response, but a reasonable response is to use lethal force to protect oneself. In that vein, the reasonableness of it cannot be removed from the context of a person that is pursuing them, a person that has thrown something at them, a person that is cornering them in between things, and a person that continues to approach even though that other person, Mr. Rittenhouse, has a weapon. I'm not disagreeing that the crux of the reasonableness for lethal force rests on the fact that a firearm was present, but I'm also saying that it cannot be taken out of context.
So hypothetically, Dr. Black, if everything else in the situation was the same, except Mr. Rittenhouse did not have that gun, is it your opinion that Mr. Rittenhouse would have been reasonable and justified to use deadly force against Joseph Rosenbaum?
If Mr. Rittenhouse did not have the weapon.
There was no weapon present.
Right. And given all the other facts as seen, there wasn't any other big fighting or kick to the head, I would argue no.
Correct.
It wouldn't be a reasonable response.
Now, after that incident, you've described how Mr. Rittenhouse travels up Sheridan Road, and you've described this crowd, and we move on to the other shootings. One of the clarifying questions I had for you was, Mr. Rittenhouse winds up tripping on his own feet and falling to the ground. No one actually pushes him to the ground or knocks him to the ground in the first place. Is that correct?
Probably so. Again, I'm not a expert on gait dynamics or anything else, but he was struck in the back of the head, knocking his hat off, and other people had been running and approach him. So it occurs within 2 steps of that event, a couple steps within that event. So it's not direct. It's not like the person got pushed down. But the idea of regaining your balance and stumbling as potentially related to that, there's a possibility. But the fact is he stumbles and he ends up on the ground, regardless of the cause.
And the first person who comes into contact with Mr. Rittenhouse after Mr. Rittenhouse falls to the ground is an African-American individual wearing a dark long-sleeve shirt, a mask, and some light-colored pants, correct?
Yes, light color pants, dark top.
This is the individual who comes in and delivers some sort of flying kick to Mr. Rittenhouse's face or head area. Is that fair to say?
Head, neck, face area, but yes.
That individual does so with his own hands in his pockets, correct?
I'd have to review the video frame by frame, but I know they were in there for at least part of it. I just can't say if they were there during the entire time.
At no point does that individual reach for Mr. Rittenhouse's gun, correct?
Not that I recall, no.
And Mr. Rittenhouse fires 2 shots at that individual from very close range and does not hit him, correct?
Correct.
Mr. Huber then comes in with his skateboard, and you characterize that situation as one in which Mr. Huber not only uses the skateboard against Mr. Rittenhouse, but also has his knees on top of him. You emphasize that point in your testimony. Is that correct?
Yes.
When you watch that video, would you agree with me that Mr. Huber's motions are primarily towards reaching for Mr. Rittenhouse's gun?
I would say that's probably, the short answer would be yes.
Would you agree with me that it does not appear that Mr. Huber intends to cause Mr. Rittenhouse physical harm with the skateboard?
I would disagree with that. And it's not that I disagree with a binary conclusion that he intended to or not. I can't tell you what his intent was.
Would you agree with me that if indeed someone like Mr. Huber, hypothetically, had a skateboard and intended to use it to cause harm, they would hold it differently than what we see Mr. Huber holding it in this video, correct?
No, I would disagree with that. I haven't been trained in understanding how to use skateboards as a weapon, so I don't have a reference point. I can tell you how to use bats and other things as a weapon and other types of things. I'm not going to say whether the grip on the skateboard was indicative of whatever Mr. Huber's intent was.
One of the reasons why you've never been trained on how to use a skateboard as a weapon is because they're generally not used as weapons, correct?
Again, I haven't done any studies on the incident rate of skateboards as weapons, so I can't speak to that.
But you would agree with me that as Mr. Huber passes over Mr. Rittenhouse's body, Mr. Huber has a hold of Mr. Rittenhouse's gun, correct?
There was multiple times he was over his body, but yes, he did have a combination of, at one point, portions of the gun in the sling and then the gun itself.
And that was, you mentioned the sling. At all times during all of these shootings, Mr. Rittenhouse was wearing the weapon, a Smith & Wesson M&P 15 semi-automatic rifle, attached to his body by a sling, correct?
The weapon was slung. It forms a type of attachment. It would seem that the sling shifted during that time. So attachment, the sling was in contact with his body and that would help it in retention. I don't know what attachment necessarily means.
With regard to Mr. Rittenhouse's shooting of Anthony Huber, is it your opinion that Mr. Rittenhouse, that it was reasonable for him to use deadly force to prevent Anthony Huber from taking the gun away and using it to kill Mr. Rittenhouse?
Well, again, I don't know what Anthony Huber's intent was, whether it was to kill Mr. Rittenhouse or not. I would argue back to your first point of the concept of reasonableness is a person had just struck me, whether it was an intentional attack or not, with a skateboard, using it as a weapon or not. I've been struck with a wooden object that moved, obviously, my balance. The same person has got now continuing, they didn't just run past me, they're continuing now to capitalize on that imbalance, try to remove the weapon from, in this case, acting as the reasonableness of a person being called Rittenhouse. And now they're, as you pointed out, jumping over or pulling away. And at that point, they are, at least it would be reasonable to believe by a person in that situation that person is trying to remove my weapon to take it from me. And then they would have control over the weapon, whether that control was to take it away or whether that control was to then use it and kill me right then and there. The reasonableness in my mind of the analysis is that a weapon taken from me would then and could then be used against me in a lethal manner.
If all of those circumstances regarding Anthony Huber and Mr. Rittenhouse are exactly the same, but Mr. Rittenhouse does not have a gun, there's no gun involved, would you agree with me that it would not have been reasonable for Mr. Rittenhouse to use deadly force to kill Anthony Huber?
I think that would be indicated more by what Mr. Huber's continued actions were. He could have still presented a future lethal threat by applying a chokehold or basically pounding a head into a pavement or something similar without the weapon being present. However, if everything else was exactly the same up into that moment of, just if I'm pulling, I don't know what I'm pulling on anymore. I'm pulling on his arm instead of the weapon as a hypothetical. If I was pulling on the arm, then not only I couldn't shoot him because I didn't have a gun and the gun wasn't there as a hypothetical, but I would not be applying lethal force for someone pulling on my arm. It's a hard hypothetical for me to fathom.
Sure, maybe I didn't phrase it very well. Let me try again, Dr. Black. Let's look at it from the perspective of a substantial risk of great bodily harm or death.
Okay.
You'd agree with me that in that interaction between Mr. Rittenhouse and Mr. Huber, if everything else were the same except there were no gun, you'd agree with me that there was not a substantial risk of great bodily harm or death to Mr. Rittenhouse, correct?
Provided that the injuries or the construct of the physical stuff into the pavement if there wasn't anything from Mr. Huber's physical actions that could potentially damage the facial area, organs, eyes, mouth, hearing by being slammed in the pavement because of the body position of Rittenhouse, then yes, I would agree with that condition.
With regard to the final shooting of Gaige Grosskreutz, you would agree with me that Mr. Rittenhouse used deadly force against Gaige Grosskreutz, correct?
Correct, sir.
Obviously, Mr. Grosskreutz wasn't killed, but it doesn't change the fact that the defendant intended to kill him, correct?
That's incorrect. I don't know what the intent was of Mr. Rittenhouse is not indicated.
Can you help us understand, in your opinion, why Mr. Rittenhouse was justified or why it was reasonable for him to use deadly force against Mr. Grosskreutz?
Oh, absolutely. And I think that's really a great question. It's the crux of the question. As you just stated, why would it be reasonable for Kyle Rittenhouse to believe that this person over there represented a potentially lethal threat? And this could be assailant 1, 2, or 3. It's the reasonable person in Kyle Rittenhouse's shoes looking outward through what he saw, his context, and his experience. And that's what I try to apply in that. So in the case of the third person, Mr. And I'll probably butcher the name, so I apologize, Grosskreutz, is that a couple things are very interesting in this one. First of all, is that Mr. Grosskreutz was approaching this scenario, this event, out of the fringes, and he sped up initially to get closer during the time when Mr. Huber was in an altercation with Mr. Rittenhouse. The round that goes off is, and the more importantly, I would argue, the muzzle flash from the shot against Mr. Huber is plainly visible within the frame and frames that Mr. Grosskreutz is seen approaching, moving, running towards Mr. Rittenhouse. So arguably, Mr. Grosskreutz knew, heard, saw indicators that Kyle Rittenhouse had fired his weapon. Mr. Huber leaves, disengages, I think is the term you used, and yet Mr. Grosskreutz continues to go forward, and that shot is what causes him to go back. You see him actually hunch down, recoil, and then move backwards. To me, the interesting thing about that is also within this frame, is within his right hand is plainly visible that would be purport to be a handgun and later determined to be a handgun. He raises his hand, handgun still in the hand. And at this point, Mr. Grosskreutz, for whatever reason, is seen moving forward again. But when he moves forward again, he actually loads, meaning that he like when you're bracing and you're about to push something, a car, a tackling dummy or whatever, you can see the stutter step and him loading, and then he comes back in. And so when he comes back in with that kind of behavior, you see the right arm coming down, and that's when you see that other muzzle flash that actually then ends up hitting him in the bicep. So it's, to me, what is significant is this idea of coming in initially, making a choice, Mr. Grosskreuz's choice, to then move backwards and then to re-engage again. And I think that is significant.
Is it your opinion that from those actions, Mr. Grosskreutz was lunging in to try and take Mr. Rittenhouse's weapon away?
No, sir, because I'm not looking at the intent of Mr. Grosskreutz. I'm looking at the reasonableness of a person in Kyle Rittenhouse's shoes perception. Reframing that is that based on those actions, I would determine that it would be reasonable that Kyle Rittenhouse or a citizen in Kyle Rittenhouse's position perceive what you just stated. I can't speak to the intent of Mr. Grosskreutz, just like I can't speak to the intent of any other assailants that we've talked about today.
So let's take it from a different angle then. What actions did Mr. Grosskreutz take against Mr. Rittenhouse that would cause a substantial risk of death or great bodily harm to Mr. Rittenhouse?
I can't answer the question in the way it's framed, because for me, I analyze it by the actions that were potentially perceived, reasonably perceived. And again, I've already stated those. The willingness to re-engage, the willingness to re-engage with a firearm in my right hand. The act of when the firearm is in my right hand is that once it's up, it begins to lower and come in my direction. moving a firearm while I'm moving forward, a person, Mr. Grosskreutz, is moving forward, and then directing that firearm towards the direction of a person such as Mr. Rittenhouse could reasonably be perceived as a lethal threat.
Do you have your preliminary report in front of you, Dr. Black?
I do, sir.
I want to turn your attention to page 24 of your report. This is where you focus in on the interactions between Mr. Rittenhouse and Mr. Grosskreutz. And on page 24, you have a number of paragraphs that are listed by Roman numeral, and one of them is Roman numeral or paragraph VII, paragraph 7. Do you see that?
Let me catch up with you. I'm sorry, did you say Roman numeral 7? It starts S3 is seen initially?
Yes.
Yes, I'm there, sir.
And your paragraph there describes the physical movements of Mr. Grosskreutz that you've also described here in your testimony. And then you say these are, and I'm quoting, these are indicators of someone that is about to either lunge or spring forward. Immediately after bracing his left foot, S3, subject 3, Mr. Grosskreutz, takes a significant step/lunge and moves towards K. Rittenhouse and could reasonably be perceived as attempting to assault, open parentheses, now with a firearm, close parentheses, or perhaps gain control of K. Rittenhouse's weapon. Did I read that correctly?
With the exception of one word off his left foot, but yes.
Oh, I'm sorry, I misread that. But otherwise, it's
no
all
worries.
correct?
Yes,
okay.
sir.
So if I'm understanding you correctly, when you are trying to describe what Mr. Rittenhouse perceived in that moment, you believe it was reasonable for him to perceive Mr. Grosskreutz as either about to shoot him with Mr. Grosskreutz's gun or take away Mr. Rittenhouse's gun.
That's
Is that fair to say?
No, it's not.
Okay. Can you help us understand, in your expert opinion, what Mr. Rittenhouse's, what it would have been reasonable for him to perceive that Mr. Grosskreutz was going to do at the moment that Mr. Grosskreutz lunges or springs forward?
Right, and I think you just stated it correctly, at least in my mind, not meant any disrespect to you, is you stated correctly in your second half. It wasn't the same way you stated there. I'm not speaking to what Kyle Rittenhouse did perceive. I have no way of knowing that. I'm not speaking to what Mr. Grosskreutz intent was. I have no way of knowing that. I have indications of that. At least he gave a statement, and we have that to go off of and weight that as we have. What I'm speaking to is a citizen in that position, given those indicators, would it be reasonable for them to believe that they were about to be assaulted? I would argue yes. That is one of the many reasonable things to perceive. They could also perceive that they wouldn't be assaulted. But I'm telling you that it would be reasonable to perceive, given those things, that they would be assaulted. Would it be reasonable to perceive, given everything else that had happened up to that point, given the fact that Huber had tried to take the weapon, given the fact that they're in wrestling match with that this guy with a gun, Mr. Grosskreutz, was potentially coming in either with his gun or is going to try to take my gun? Would it be reasonable to perceive that? I would argue yes. That is one of many reasonable perceptions in that situation. Does that help?
It does. And just so we're clear, when you are describing the actions of Mr. Grosskreutz as posing a substantial risk of death or great bodily harm to Mr. Rittenhouse, this is what we're talking about, correct?
Almost. I've never described the actions in the terms that you used. What I described was it would be reasonable for Kyle Rittenhouse to perceive that they could be serious potential lead-ins, indicators, precursors to actions that would result in serious bodily harm and or death. Okay.
So just so I'm understanding you correctly, Dr. Black, your testimony, your opinion is that a reasonable person in Mr. Rittenhouse's position, seeing Gaige Grosskreutz lunging towards him with that gun in his hand, the gun possibly lowering and pointing towards Mr. Rittenhouse, that it would be reasonable for Mr. Rittenhouse to believe that Mr. Grosskreutz posed a significant or substantial risk of death or great bodily harm in that moment, correct?
Correct. And within the context of, just keep everything just like you said, and I would add to that, and within the context of a person that had been previously attacked twice, had a crowd surrounding him with weapons, had already been running and that kind of stuff. But just add in the context, and yes, I would agree with everything you said.
And to be even more precise, a reasonable person in Mr. Rittenhouse's position at that point would be reasonable for them to perceive that the substantial risk of death or great bodily harm comes from either Mr. Grosskreutz shooting Mr. Grosskreutz's gun at Mr. Rittenhouse, or Mr. Grosskreutz taking Mr. Rittenhouse's gun away and using it on Mr. Rittenhouse.
Or the entire crowd descending on him and using the wooden objects and bats and everything else they were running out of. But yeah, the short answer is those two would be indicator. But since we don't have Mr. Rittenhouse's perceptions at that time, the fact is any of those could be those being some of the obvious ones.
Dr. Black, are you suggesting that a reasonable person in Mr. Rittenhouse's situation was entitled to shoot Mr. Grosskreutz to protect himself against threats posed by other people?
No, I didn't suggest that.
Okay. Now, if I'm understanding this situation with Mr. Grosskreutz correctly, we've talked about the threat of Mr. Grosskreuz's gun. Is the crux of that perceived threat the notion that Mr. Grosskreutz was pointing the gun at Mr. Rittenhouse?
It's part of it. The word crux being a singular thing, I would argue no. Again, to take everything out of context it's not part of the reasonableness inquiry. We dissect it and we put it back in. Did pointing the gun have something to do with it? Absolutely. Did approaching and actually waving the gun have something to do with it? Absolutely. Did the fact that you approached him and then moved back to move back in have something to do with it? Absolutely. Whichever you want to call the crux, that's fine. I'm not going to argue for or against, because all of them contributed.
I have no further questions, Your Honor.
Going to Mr. Huber attacking Kyle Rittenhouse with the skateboard. A skateboard could be a deadly weapon, correct?
The ones I've seen, they're laminated wood, very, very strong. The same thing that they make shinais and other type of things in martial arts out of. They have metal wheels, and could they actually rip out an eye or break a neck? I would see. I mean, I could tell you that in my training, I could do it with a skateboard.
And so a skateboard is an object that could cause great bodily harm or death, is your testimony, correct?
Yes, sir.
And the real big issue in that would be the location of the strike, neck and head versus, say, to the body.
Yeah, I mean, a skateboard as an impact type of weapon, meaning it's generating force and then transferring that force into something, muscle tissue, bone, organ, whatever, is one, if I use the edge of the skateboard compared to the flat side of it, it's going to generate a lot more force. And if I strike you in the thigh with it compared to strike you within the neck or the head, that force then is going to be applied against something that isn't designed to take force. And so the edge of the skateboard, a wheel of a skateboard being swung in a centrifugal arc against the head and neck area, and also take into position here, a person in motion, just like a wind up, and then a person on the ground, which means that they don't have a lot of ways of getting out of the way, let alone not even looking in that direction. And they're being stabilized by the ground, meaning the force has a greater chance of being transferred from the swing into the tissue, the organs, the eyes, or whatever. So, yes.
And when Mr. Binger was going over your CV exhibit number 2 and saying they were in a law enforcement setting, you testified for plaintiffs against law enforcement, correct?
Right. And I apologize to the court if I misheard. What he said was where a law enforcement agency was present. That wasn't the fact that I testified for the law enforcement agency or I testified against a law enforcement agency. In a rough estimate, probably about 20% of the casework I do is actually against police agencies. And the reason being is I primarily do my work as a way of instituting change. So, yes.
And your opinions in this case are based upon factors that sometimes apply in law enforcement cases, but in this case, you're reviewing it from a citizen standpoint and their right to engage in self-defense.
From multiple things, the attention factors, the things we talk about, sense making, the things that I put within my report that are preamble, perception, attention, how we do that, those are human things. It doesn't matter whether you're a police officer, an Olympic athlete, or anything else. Some are better at it than others, but as a human organism, they govern. They are found throughout research in multiple things. Second to being a human is your training. And in this case, police officers. And to the state's point, which I agree with, we add another layer on top of that type of analysis, rules and standards and training that's been applied and accepted practice and these type of things. But the overarching thing that's the same regardless is you're human first. After that, I take a look at the statutes, those that apply to a peace officer as compared to those that apply to a citizen, and I apply the appropriate standards based on their locale, their precedents against the case as well.
I have nothing further. Thank you, Doctor.
Any question?
No, Your Honor.
Thank you, Doctor.
Yes, sir.
Do you have more, Mr.?
I do not, Your Honor.
Mr. Let's take a break.
Your Honor, we had discussed with your clerk the possibility of conducting the hearing with regard to Mr. Willis at a later date after we've got his report. And we talked about the afternoon of October 25th, which I think works for all parties. So I don't know if it makes any sense to start with, today we'd be talking about his qualifications, which we can do, but it might be simpler just to do it all at the same time. I don't know what the court feels, but there's...
That would be fine with me, and you can...
Fine with me.
You can...
I didn't run that date past Mr. Willis. Mr. Willis, are you available on the afternoon of October 25th?
Let me check, and let me also add, I'm probably going to be kicked out of this building in 10 minutes.
Oh, well.
All the more reason to stop.
So would that afternoon work for you, Mr. Willis?
I'm checking right now.
Thank you.
That would be a Monday. Monday, the 25th of October. Believe it or not, I have a trial starting, guess where? In Kenosha. The Smith versus Bandy trial, but it's going to be day one. And I'm certain I would not be called on day one. So yes, I should be available.
2:15 works for us. Mr. Willis, does 2:15 that afternoon work for you then?
That'll be fine, and that'll be on Zoom again, correct?
Is that okay with you, Your Honor?
Well, if he's in Kenosha...
He lives in Wauwatosa. Would you be able to come down in person that day?
Oh, I didn't realize. Well, if he's going to be in Kenosha...
I'm not going to be in Kenosha. I'm just have a trial starting that day in Kenosha. I'm about an hour away in the Milwaukee area.
Okay, Zoom will be okay.
We can do it by Zoom, Mr. Willis. Thank you.
Okay.
All right.
What time?
Anything else?
2:15?
2:15, yes.
All right.
Right. Thank you. Thank you. Enjoy the day.
Thank you.
Galaxy S9 waiting to come in. Hope somebody hasn't been waiting for.
He said he'll have it by October 18th.
Galaxy S9 just entered the room. Would you identify yourself, please? Galaxy S9? See, there isn't.
Your Honor, this is Dr. Black, just making sure that at this point I'm free to go.
You are. Thank you, Doctor.
Yes, sir.
Okay. All right. I'm cutting it off.